Hi friends, I am Professor Kshitij Bansal. I teach law at Jindal Global Law School. I am going to brief you today on the topic Rights of Indigenous People. What is there for you to learn out of this module? This will introduce all of you to Indigenous people, who they are, where they belong to, and history and development of Indigenous rights. You would also learn various instruments which are responsible for the protection of Indigenous people's human rights. Indigenous people are those people who live within a nation state prior to the formulation of the nation state itself. But these people do not identify themselves with the dominant nation. International Labour Organization provides for certain criteria for the identification of Indigenous people. These are as follows: descending from a population who inhabited a particular region at the time of conquest, colonization or establishment of state boundaries, who retain some or all of their own social, economic, cultural and political institution irrespective of their legal status, who have many distinguishing features which make them different from the other section of the national community, who have their status wholly or partially recognized by their own customs or traditions or by special law or regulation, who identify themselves as indigenous people. Indigenous peoples are generally defined as people living in an area within a nation state prior to the formation of a nation state, but who do not identify with the dominant nation. Generally, they are people who have inhabited a land before it was conquered by colonial societies currently governing those territories. The international institutions have added certain other criteria, such as a special relationship with land and natural resources, a history of oppression and ongoing conditions of non-dominance, and aspirations to continue to exist as distinct people. Analyzing in this context, it is generally estimated that Indigenous people constitute around 370 million people spread across some 90 odd countries around the world. Almost all the countries in the world, Indigenous people are the poorest and the most marginalized groups. The rights of Indigenous people have received serious attention in the past 3 decades, and as a result, at international level, various human rights instruments were taken up for protection and upliftment of Indigenous people. One of the notable features of these instruments is that it views the rights of Indigenous people as a collective or group right rather than an individual right. This is because the very claim for rights by Indigenous people is based on the fact that they are indigenous, which is a group characteristic, a collective community characteristic. Rights of Indigenous people, a collective or group right, let's talk about it now. Indigenous people are subjects of international law and they are entitled to specific collective human rights which have been evolving over the last decades. Collective rights address the group, not the individual as right holder, and complement individual human rights. To most Indigenous people, the individualist conception of human rights is an alien concept. Instead, the community is the entity of reference and individuals and community are seen as inseparable. Thus, collective rights are instrumental for ensuring Indigenous people's rights to self-determination. Ancestral territories, land and other resources, participation in decision-making and consent, as well as development with identity, a concept increasingly used in Latin America. The cornerstone of Indigenous people's collective rights is their recognition as people. It is to be noted that an exclusive emphasis on individual rights has not and cannot give effective guarantees for Indigenous peoples who require the simultaneous protection as collectivities in order to survive and flourish as distinct people and cultures. Collective rights emphasize the value of protecting Indigenous cultures and existence per se and reject assimilation and integration as valid models of relating to Indigenous people. it can be seen that major sources of collective human rights of indigenous people are ILO, Indigenous and Tribal Peoples Convention number 169, 1989, and the UN Declaration on the Rights of Indigenous People of the year 2007. Some of the collective rights specific to indigenous people are right to self-determination and to lands, territories and resources, to recognition of treaties and the right not to be subjected to forced assimilation, destruction of culture, genocide or any other act of violence, to rights affirming indigenous spirituality, culture, education and social welfare, etc. Protection of rights of indigenous people, let us have a historical account of this. The protection of the rights of indigenous people became an issue from the 16th century due to the expansion of trade and commerce and the competition between various invaders all over the world. One of the oldest documents which outlines the basic concept of indigenous people's rights is De Indis et de Jure Belli Reflexiones. It is written by Francisco de Vitoria in 16th century. In this, he discussed the discovery of indigenous population of North America by Spanish adventurers and the violation of the rights of these people, and dealt with the rights and duties of each other. This book created awareness regarding the rights of indigenous people and influenced other scholars to do research in this area. Hugo Grotius, a Dutch scholar, published a treatise on Aboriginal rights entitled De Jure Parede Commentarius. Grotius adopted many of Victoria's concepts and beliefs. These two works were criticized by Samuel Pufendorf, a contemporary of Grotius, in his renowned work De Jure Nature et Gentium. The work of these three scholars is significant because all three recognize the importance and existence of certain fundamental rights of indigenous peoples in international law. Their views were adopted by some modifications by Emmerich Vattel in mid-18th century. However, these works created only awareness about the rights of indigenous people. The real impetus towards the protection of indigenous people's rights was after World War I and World War II, when the indigenous people started to agitate and claiming more rights against the colonial rulers. As a result, the colonial rulers led by European countries were forced to grant more rights to those indigenous or aboriginal people. At international level, the two main organizations concerned with the rights of indigenous people are International Labour Organization and United Nations. In 1957, the International Labour Organization adopted a convention concerning the protection and integration of indigenous and other tribal and semi-tribal populations in independent countries, Convention number 107. It contained articles on general policy, land, employment, training, education, rural industries, social security, health and administration. The convention provides that the rights of ownership, collective or individual, over the lands of members of indigenous and tribal populations are recognized, and that populations concerned shall not be removed without their consent. In cases where removals are necessary, people are to be provided with lands of quality at least equal to that of the lands they occupied previously. Compensation is to be provided in kind or in cash or both for losses suffered. This was the first international effort to establish a set of standards for protecting indigenous peoples. The emphasis in this convention was on integration rather than on recognition of the distinct characteristics and rights of theirs. However, it suffered from various drawbacks, and as a result, it was revised by ILO. Finally, in the year 1989, ILO adopted Convention number 169 concerning indigenous and tribal people in independent countries. It confers international recognition on the specific rights of indigenous people and has already been ratified by many nation states, making it applicable domestically in those countries. The United Nations has also taken concrete steps for protecting the rights of indigenous people. In 1982, a working group on indigenous people was created under the auspices of UN Subcommission on the Prevention of Discrimination and Protection of Minorities. This working group prepared a draft Universal Declaration of the Rights of Indigenous Peoples. This draft declaration was adopted by UN Subcommission on the Protection of Sexual Minorities and the Prevention of Discrimination in 1994. Finally, the UN General Assembly adopted this draft declaration as Declaration on Rights of People, Indigenous People in the year 2007. Considering the growing importance and recognition of the rights of indigenous and tribal people, the United Nations General Assembly declared the year 1993 as the International Year for the world's indigenous people. Further, the UN General Assembly in 1993 declared the first International Decade of the world's indigenous people. Its main objective was to strengthen international cooperation to solve problems faced by indigenous people in areas such as human rights, environment, development, education, and health. So, also the United Nations constituted the UN Voluntary Fund for Indigenous Decade to finance indigenous activities and programs in the year 1993. The UN General Assembly decided on 23rd December 1994 to observe 9th August every year as the International Day of World's Indigenous People. In the year 2000, the UN established the UN Permanent Forum on Indigenous Issues. This forum formally integrates indigenous peoples and their representatives into the structure of UN. It placed state and non-state actors on an equal footing in a UN permanent representative body for the first time. Its mandate is to discuss and provide recommendations on indigenous people issues relating to economic, social and cultural, developmental, environmental, educational, health and human rights related issues. Another landmark development in the year 2011 was the appointment of UN Special Rapporteur on the situation of human rights and fundamental freedoms of indigenous people. Subsequently, the year 2005-2010 was declared as the second International Decade of World's Indigenous Peoples. Its main aim was to further strengthen international cooperation to solve problems faced by many indigenous peoples groups. The United Nations has also established an interagency support group on indigenous issues in year 2005 for the purpose of supporting and promoting the mandate of the UN Permanent Forum of Indigenous Issues within the UN system. Its mandate was later expanded to include support to mandates related to issues of indigenous people throughout the intergovernmental system. Yet another major development was the establishment of United Nations Indigenous Peoples Partnership, UNIPP, in the year 2011. This system was developed by 4 institutions: the UN International Labour Organization, UN Development Programme, the UN Office of High Commissioner of Human Rights, and the UN Children's Fund. It is designed to implement provisions of the UN Declaration on the Rights of Indigenous People 2007. The international instruments for the protection of indigenous peoples' human rights. Let us now talk about these. At the international level, there are numerous instruments which protect and promote the human rights of all individuals. Though these documents are not specifically dealing with the rights of indigenous people, they are applicable equally to indigenous people also, and various provisions in these documents are relevant for the protection and promotion of their rights. For example, UN Charter establishes the foundation for the protection of rights of indigenous people by incorporating the provision of the right of self-determination for all people and the duty of all states to promote human rights, including the right to be free from discrimination on the basis of race, sex, language, or religion. The Universal Declaration of Human Rights, 1948, states that all human beings are equal in dignity and rights. UDHR provides that everybody is entitled to the rights in the Declaration without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. The International Covenant on Civil and Political Rights, 1966, which we conveniently call ICCPR, in its Article 27 mentions that in those states in which ethnic, religious, or linguistic minorities exist, persons belonging to such minorities shall not be denied the right, in community with the other members of their group, to enjoy their own culture, to profess and practice their own religion, or to use their own language. All these above provisions, which embody the right to self-determination, right to equal dignity, and right to enjoy your own culture, are very important in the context of Indigenous people, as they are often discriminated and marginalized in societies based precisely on these factors. It is to be noted that various international instruments on human rights address the issue of discrimination, and hence they are also relevant equally for protecting the rights of Indigenous people. The International Convention on the Elimination of All Forms of Racial Discrimination, 1963, defines racial discrimination as any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life. The Convention on the Rights of Child, 1990, contains various regulations and suggestions on non-discrimination of children. Article 29 mentions right of minorities to education, including education on human rights, and to maintain its own cultural identity, language, and values. Further, Article 30 of Child Rights Convention states that children of minorities or indigenous origin shall not be denied the right to their own culture, religion, or language. Another important document now is the Declaration on the Rights of Persons Belonging to National or Ethnic, Religious, and Linguistic Minorities, 1992. It deals with all minorities, which include many of the world's indigenous people. It deals with rights of minority people as well as the state's obligations towards them. It addresses the issues of national or ethnic, cultural, religious, or linguistic identity of minorities, the free expression and the development of culture, association of minorities amongst themselves, participation in decisions regarding minority, the exercise of minority rights, both individual and in groups, the education of minorities, and many others. The Vienna Declaration and Programme of Action adopted in the World Conference on Human Rights, 1993, recognizes the inherent dignity and unique contribution of Indigenous people to the development and plurality of society, and strongly reaffirms the commitment of the international community to their economic, social, and cultural well-being. So also the report of International Conference on Population and Development in the year 1994, which specifically states that the perspective and needs of Indigenous people should be included in population development or environmental programs that affect them, that there should receive population and development related services that are socially, culturally, and ecologically appropriate. It also highlights that Indigenous people should be enabled to have tenure and manage their own land and protect the natural resources and ecosystems on which they depend. The international law has also paid attention to the role of Indigenous people in protection of environment and their right over biodiversity and traditional knowledge. The Rio Declaration of Environment and Development and Agenda 21, 1992, which were adopted in the Earth Summit in Rio de Janeiro, recognize the special relationship between Indigenous people and their lands. It accepts that the Indigenous people have a vital role in environmental management and governance and the development because of their traditional knowledge and practices. Agenda 21 highlights that for effective utilization of traditional knowledge, Indigenous people might be given greater control over their land, self-management of their resources, and participation in development decisions affecting them. Further, the Convention on Biological Diversity 1992 calls upon its signatories to respect, preserve and maintain knowledge, innovations and practices of indigenous and local communities, embodying traditional lifestyles relevant for conservation and sustainable use of biological diversity, and promoting their wider application with the approval and involvement of stakeholders of such knowledge, innovation and practices, and encourage the equitable sharing of the benefits arising from the utilization of such knowledgeable innovations and practices. The UN Convention to Combat Desertification 1994 also emphasizes on the protection of indigenous traditional knowledge, technologies and practices. The Declaration of Atitlan 2002 also emphasizes the importance of indigenous peoples' rights to lands, natural resources and self-determination, to their overall food security and sovereignty. Further, Article 9 of Anchorage Declaration 2009 calls upon UN agencies to address climate change impacts in their strategies and action plans, especially with regards to indigenous people. The two specific and most important documents that address the rights of indigenous peoples in the world are the International Labour Organization's Convention number 169 of 1989 and the UN Working Group on Indigenous Populations Draft Declaration of the Rights of Indigenous People 2007. The Convention number 169 is the first international instrument which deals specifically with the rights of indigenous people. This convention is a legally binding document open to ratification, and it has been ratified by around 20 countries. The convention consists of a preamble followed by 44 articles and can be divided in 10 parts. This convention deals with various issues like land, rights, employment, vocational training, social security and health, means of communication and cooperation. The convention states that governments shall have the responsibility for developing a systematic and coordinated action to protect the rights of indigenous and tribal peoples and ensuring that appropriate mechanisms and means are available for their integration within the other sections of the society. The greatest achievement, the greatest significance of this convention is that it can be used as a tool for communication between governments and indigenous people and prevent any possible conflicts between these two stakeholders. The Declaration on the Rights of Indigenous People was adopted by the United Nations General Assembly itself in September 2007 by a majority of 144 states in favor and 4 states against, with 11 abstentions. The declaration consists of the preamble, 46 articles. It recognizes various human rights and fundamental freedoms of indigenous peoples, such as the right to unrestricted self-determination and inalienable collective right to the ownership and control of lands, factories and other natural resources, their rights in terms of maintaining and developing their own political, religious, cultural and educational institutions, keeping in mind the mandate, along with the protection of their cultural and intellectual property. The declaration also highlights the need for prior and informed consultation, participation and consent in activities of any kind that have an impact on indigenous people, their property or territories. It also establishes the need for fair and adequate compensation for violation of the rights recognized by the declaration and establishes guarantees against genocide. And declaration also provides for fair and mutually acceptable procedures to resolve conflicts between indigenous peoples and states, including procedures such as negotiations, mediation, arbitration, national courts and international and regional mechanisms for denouncing and examining human rights. An analysis of all the above international instruments shows that there is great concern for rights of indigenous people at international level. These international instruments protect various collective rights of indigenous people, such as right to self-determination, collective right to ownership, use and control of the lands, territories, and other natural resources, their rights in terms of maintaining and developing their own political religions, cultural and educational institutions, along with the protection of their cultural and intellectual property, etc. However, it is to be noted that only the ILO Convention 169 is legally binding and all other instruments are merely a voluntary guideline to the state. Thus, in the absence of such a binding obligation, it is difficult to ensure the realization of these rights by the states in reality. Would you agree that we can conclude by saying that this module has introduced us to a holistic understanding of what are and who are Indigenous people, they stand in the society. Further, this module dives into the protection of rights of Indigenous people, the various international instruments which are responsible for ensuring the protection of Indigenous people, and other various provisions of the United Nations. I hope you have gained a lot from this module. Thank you so much for listening.